Hi, welcome tonight. This is Pam Caruso with the League of Women Voters in Tennessee Valley. We are hosting this forum tonight to try to bring some clarity to the 6 constitutional amendments that you're seeing on your ballot. We've heard from several people in the community. I've had people call me up personally asking us how to vote on these amendments. And we decided this was an area that voters needed information to make an informed decision. So I'm joined tonight by 2 very knowledgeable gentlemen, Julian Butler and David Persons, who we believe can shed some light on the 6 amendments and try to put them in plain language so voters can understand and feel informed to make their decisions. A little bit about Julian Butler. Julian has been in private law practice in Huntsville. He served as the county attorney for Madison County for 35 years, and he has served as the president of the National Association of County Civil Attorneys. He also served as a special assistant attorney general for the state of Alabama. Julian serves on several state boards, such as the Alabama Department of Archives and History, and the board of directors of the Alabama Citizens for Constitutional Reform Foundation. The first time, I'd like to say that the first time I ever heard Julian speak, it was at the state bicentennial, and he talked about the constitutions and how they all came about and why we are where we are. And the other person is David Person. David is a media personality and consultant who has been working in the Huntsville area since 1986 as a talk show host, a columnist, and a director and a producer. His work has been featured on NPR and public radio stations across the nation. David co-hosts the podcast Alabama Politics This Week, and David is an alumnus of Oakwood University. And I'm going to hand it over to David to lead this event for us.
Thanks, Pam. Good evening to everyone. And Pam, I want to thank you and the League of Women Voters in the Tennessee Valley for producing such a great and I think important event. And I'm saying that not because I'm here, but because I think many people often go to the voting booth either completely unfamiliar with the amendments or with a vague familiarity with the amendments. And so here's a great opportunity for people to get clarity and to get some expert analysis on these amendments from my good friend Julian Butler, and also to hear what the League of Women Voters position is. So I want to again commend the League of Women Voters of the Tennessee Valley for this event. So we've got 6 amendments on the ballot. I'm going to read a summary, a very short summary of each one, and then go into our discussion with Julian. So the first amendment, Amendment 1, has been summarized by the League of Women Voters as being an amendment that basically says only a citizen of the United States has the right to vote. That's Amendment 1. Only a citizen of the United States has the right to vote. And again, these are summaries that have been provided by the League of Women Voters of the Tennessee Valley. Amendment 2 has been summarized this way. It includes 6 changes to the state's judicial system. And of course, we're going to go through those changes with Julian. He'll guide us through those in just a few minutes. Amendment 3 changes the initial term of a judge that is appointed to fill a vacancy. Julian will explain that to us. Amendment 4, allowing the legislature let me reread that. Amendment 4 will allow the legislature to draft a rearranged version of the state constitution. That sounds very intriguing, and I'm sure Julian will have a very thoughtful and interesting analysis about that. Amendment 5, Franklin is specifically for Franklin County. It will only apply in Franklin County. And you know, Alabama has amendments that always show up on the ballot that are unique to a county or specific to a county. And in this particular case, this amendment for Franklin County only would allow deadly force in self-defense on church premises, on the premises of a church. All right. That's only for Franklin County. Amendment 6, only for Lauderdale County, would allow deadly force in self-defense, again, on church premises. Interesting. Interesting pattern there. All right, so we're about to launch into an in-depth conversation with Julian Butler about these amendments. But first, Julian, let's get into a little background, help people to understand, especially for those who are new to Alabama or new to voting in Alabama. They may not even understand why amendments are put on the ballot. Can you explain why that is and what that process entails?
Yes, David, and I want to endorse your comments thanking the League of Women Voters. This is truly a service to all of those people who want to know more about the 6 constitutional amendments. And I want to say something in the beginning. I will express my opinion on some of these issues. And I want to stress to you, it's my opinion. It is not necessarily the opinion of the League of Women Voters, not necessarily the opinion of my law firm. It is my personal opinion. With that said, the Constitution of the United States has a broad framework for how government should be run. It seldom been amended. There are only 27 amendments to the United States Constitution since 1789. The Alabama Constitution of 1901 is micromanagement taken to the ultimate extremes. It deals with a lot of subjects that have no business being in a constitution. It is the longest constitution in the world, we have been told. It is 50 times the length of the United States Constitution, and it has, by the last count I did, 944 amendments, which points out just how bad it is at micromanaging. Of the constitutional amendments on the ballot, the first 4, 1, 2, 3, and 4, change things that now are in the Alabama Constitution. So the only way you can change them is by changing the Constitution. And for a constitutional amendment to be adopted, it must receive a vote of 3/4 of the State House of Representatives, 3/5 of the House of Representatives, 3/5 of the State Senate, and then go on the ballot and be adopted by a majority of the people at the election. The last 2, the local amendments, and there are, again, at my last count, 223 local amendments to the Alabama Constitution. The reason that these have to be, under Alabama law, you cannot have things related to criminal matters that affect only one county. The legislature can't do that. So the only way you accomplish that is by a constitutional amendment affecting just that one county. These are on the statewide ballot. When you propose a local constitutional amendment, it must get the 3/5 vote of the House of Representatives and the 3/5 vote of the Senate. If there are no dissenting votes in either the House of Representatives or the Senate, then it goes on the ballot only in the county that it affects. These would be only on the ballot in Franklin County or in Lauderdale County. But when they were before the legislature, there was at least one dissenting vote in one of the other houses on them. And that puts them on this ballot. And they must carry the state at large and the voters of either Franklin County or Lauderdale County. It is a convoluted procedure, as most things with the Alabama Constitution are convoluted. David, I hope
Right.
that answers your question.
Well, yeah, I think it does, and actually goes even beyond answering that question. I think really helping to give us some historical context. Thank you for that. Um, all right, so I think you've covered most of the significant points, if not all of them, related to our Constitution and its complexity and why we have to go through this amendment by referendum process. So now let's go ahead and let's start examining the amendments themselves. So what I'm going to do, Julian, is I'm going to read the actual verbiage as it will be on the ballot in November. That's already available on the Secretary of State's website. So anybody can go to the Secretary of State's website and read this same verbiage. I'm going to do that. And then I'm going to go through the summary of it as the League of Women Voters of the Tennessee Valley have prepared it. And then we'll get your analysis, and we'll get also, I'll state the League of Women Voters position on the amendment. So we'll start with Amendment 1, which is sponsored by Senator Marsh. And the Amendment 1 proposes an amendment to the Constitution of Alabama of 1901 to amend Article 8 of the Constitution of Alabama of 1901, now appearing as Section 177 of the official recompilation of the Constitution of Alabama of 1901, as amended, to provide that only a citizen of the United States has a right to vote. That is the amendment as it will appear on the ballot. And now let's go through some questions. In fact, well, let me do this. Let me go through a layman's sort of summary of this amendment that the League of Women Voters have prepared, and then we'll get to Julian's analysis and any questions. All right, so the League of Women Voters have summarized this using layman's language or common language without the legalese this way. Amendment 1 proposes an amendment to amend Article 8 of the Constitution of 1901, which now appears as Section 177 of the official recompilation of the Constitution of Alabama of 1901, to provide that only a citizen of the United States has the right to vote. The Secretary of State summarized it in plain language this way: the state constitution grants the right to vote to U.S. citizens who meet certain requirements. This amendment does not change those requirements according to the Secretary of State. So if a majority of voters vote yes for this amendment, the state constitution will grant the right to vote to only those U.S. citizens who meet the specified requirements. Okay, that's the League of Women Voters summary, which also includes the plain language from the Secretary of State's website. Julian, what's your analysis of Amendment 1?
If I can be very frank, this is one of the silliest amendments I've ever seen to the Alabama Constitution. It changes one word only. Now, the section of the Constitution that deals with the right to vote has the requirements of who can vote and that kind. That's not changed. Now it says it will grant the right to vote to only those U.S. citizens who meet the requirements. Now it says that grant the right to vote to every U.S. citizen. The change would be delete the word every and insert the word only. Now, I can't see that is a distinction without a difference, or a difference without a distinction, or whatever you want to say. What I understand that the background of this probably started 3 years ago, maybe. It was a fear of those people that are concerned about undocumented immigrants. Somehow that there was a conspiracy to allow them to vote, and that there'd been widespread fraud and they'd been allowed to vote. I have been told, I have not talked to Senator Marsh, I don't know what prompted him to do it, but that appears to be the background of it. And as I say, I don't see any difference. It merely changes that the right to vote to every U.S. citizen to the right to vote for only U.S. citizens. I am going to vote no on Amendment 1. I think it's useless.
Okay, okay. That does seem to be, as you've said, a distinction without a difference. I have a question here. Apparently, there are amendments similar to this one, or maybe exactly like this one in other states. Is there some sort of a nascent national movement here to institute this this specific amendment in other states, perhaps for the same reason?
David, I don't know, but that would be my assumption. That, again, people who are very concerned about undocumented immigrants and why this became a touch point for them. And as I say, I don't see that it accomplishes anything.
Okay. Okay. So the League of Women Voters position is to encourage voters to vote no, as you plan to do, Julian. The League of Women Voters says that if this amendment passes, the Alabama Constitution will not affirmatively state that every citizen has the right to vote, potentially becoming less inclusive. Does that jive with your point of view?
It does, but I'm not sure even that. I don't disagree with the league. I'm not sure it changes anything. I don't know the difference between every and only. I just, as I said, I think it's a distinction without a difference.
Okay. We'll move on, Julian, to Amendment 2, which was sponsored by North Alabama Senator Arthur Orr and co-sponsored by Senator Ward. So I'm going to read the language exactly as it is on the ballot. Proposing an amendment to the Constitution of Alabama of 1901 to increase the membership of the Judicial Inquiry Commission and further provide for the appointment of the additional members. Further provide for the membership of the Court of the Judiciary, and further provide for the appointment of the additional members. Further provide for the process of disqualifying an active judge. Repeal provisions providing for the impeachment of Supreme Court justices and appellate judges, and the removal for cause of the judges of the district and circuit courts, judges of the probate courts, and judges of certain other courts by the Supreme Court. Delete the authority of the Chief Justice of the Supreme Court to appoint an administrative director of courts. Provide the Supreme Court of Alabama with authority to appoint an administrative director of courts. Require the legislature to establish procedures for the appointment of the administrative director of courts. Delete the requirement that a district court hold court in each incorporated municipality with a population of 1,000 or more where there is no municipal court. Provide that the procedure for the filling of vacancies in the office of a judge may be changed by local constitutional amendment. Delete certain language relating to the position of constable holding more than one state office. Delete a provision providing for the temporary maintenance of the prior judicial system. Repeal the office of circuit solicitor and make certain non-substantive stylistic changes. That is a ridiculous mouthful. Now, here is the summary that the League of Women Voters has provided us with of Amendment 2. This amendment proposes 6 changes to the state's judicial system. Plain language from the Secretary of State site puts it this way: provides the county district courts do not have to hold city court in a city with a population of less than 1,000, allows the Alabama Supreme Court, rather than the Chief Justice, to appoint the administrative director of courts, increases from 9 to 11 the total membership of the Judicial Inquiry Commission, and determines who appoints each member. This commission evaluates ethics complaints filed against judges. The governor, rather than the lieutenant governor, would be allowed to appoint a member of the court of the judiciary. And this is the court that hears complaints, again, filed by the Judicial Inquiry Commission. This amendment would also prevent a judge from being automatically disqualified from holding office simply because a complaint was filed with the Judiciary Inquiry Commission. And finally, it would provide that a judge can be removed from office only by the court of the judiciary. Well, that was a lot easier to understand. Julian, take it away.
The only provision of any real importance in all of this is that it allows the Alabama Supreme Court, rather than the Chief Justice, to appoint the administrative director of courts. That is a very important position. The administrative office of courts, which is housed in the Supreme Court, is really the administrative office of the whole court system, not just the Supreme Court and the Court of Criminal Appeals and Court of Civil Appeals, but has a lot of authority and interaction with all of the circuit and district courts all over the state. The person that holds that position is a very powerful person and needs to be a person of great competence. At this time, that person is appointed by the Chief Justice of the Supreme Court. And the practice has been, each time we get a new Chief Justice of the Supreme Court, the old person goes out and a new person comes in. This really was brought to fore that over the last 20 years, no Chief Justice of the Alabama Supreme Court has served a full 6-year term. You've had that kind of turnover in the administrative office of courts and with the administrative director of courts. This is to stabilize that situation. With the changes each time a new Chief Justice comes in, you've had programs that might be working well have been abandoned and new programs brought in. And this is an attempt to stabilize it and have the entire Supreme Court, all 9 members, select this person. And it gives the legislature a right to put some procedure in regard to the length of term when they have to do it or whatever. But it is a needed stabilization of a very important position. The one that's kind of funny is that it provides that county district courts do not have to hold city court in a city with a population of less than 1,000. That doesn't happen anywhere in Alabama. That is a non-starter. The small towns, if they have their own city courts, there is no district judge in Alabama, what I've been told. Now, I hadn't checked this, but the information supplied to me that there's no district court judge in Alabama sitting as a city judge in a city of a population of less than 1,000. The other 4 relate to the Judicial Inquiry Commission. And the Alabama Constitution has set out a really good manner of dealing with complaints against judges. You have the Judicial Inquiry Commission that hears the evidence much like a grand jury and then brings, if there is basis for it, charges against the judge. It then goes to the court of the judiciary that hears the complaint and determines it. This would provide, rather than any other body having the right to remove a judge, that the decision of the court of the judiciary would be the equivalent of impeaching a judge. And now if charges are brought, the judge is automatically disqualified. This sets up a procedure where a determination is made. If a judge is indicted for a felony, they're automatically removed. But if whatever the complaint is, a decision is made whether the judge ought to be removed pending a disposition of the charges. This is a system that has been in place 40 years, probably has worked very, very well. These are technical changes that I think will benefit the system. I am going to vote yes on amendment number 2. And as I say, the only thing to really focus on is that it would make the whole Supreme Court the decision maker as far as who is the administrative director of courts, rather than solely the Chief Justice. Hopefully bring some stability to that position.
Sure, sure. I have one question for you, but before I ask that question, I want to make clear that the League of Women Voters does not take a position on this amendment at all. So they have decided to take a pass on this one. Now, I want to ask you about the one that you really didn't mention, and that's the one that removes from the lieutenant governor the authority to appoint a member to the court of the judiciary and gives it to the governor instead. I think that's a little curious, considering especially that the Republicans control the executive branch. I wonder what that signals to us, if anything, if not legally or from a judicial standpoint, maybe from a political standpoint.
I do not know the background of it. And let me say that. I don't know what prompted it. From a legal point of view, it makes very little difference as whether the appointment is made by the governor or the lieutenant governor. What prompted somebody to put this in here, I don't know. But I think it is political, not legal.
Well, that's my assumption too. And I think we have seen, and not to get off track here, but I think we have seen that the lieutenant governor and the governor have thrown some elbows over some issues during this term. So maybe that's a reflection of that. I don't know. Speculation on my part. Let's move on to Amendment 3. This is the way Amendment 3 reads, and this, by the way, was sponsored by Representative Faulkner and co-sponsored by Representative, I believe you pronounce that Freedy. Pronouncing an amendment to the Constitution of Alabama of 1901 to provide that a judge, other than a judge of probate, appointed to fill a vacancy would serve an initial term until the first Monday after the second Tuesday in January, following the next general election after the judge has completed 2 years in office. Now, again, the League has provided us with a plain language or a layman's sort of summary of that. And the League summary says that proposing an amendment to the Constitution of 1901 to provide that a judge, other than a judge of probate, appointed to fill a vacancy would serve an initial term until the first Monday after the second Tuesday in January, following the next general election after the judge has completed 2 years in office. Plain language changes the initial term of a judge that is appointed to fill a vacancy due to death, resignation, retirement, or removal. Current law stipulates that a judge has to complete 1 year in office or the remainder of the original term, whichever is longer. All right, Julian, what is your analysis here?
I am told that the impetus for this came from Jefferson County. And there have been situations where judges were appointed, they had to run, they've served just a year, they then had to run and they were defeated, and there had been a lot of turnover. I think the argument for it, and I am going to vote yes on this amendment, is if somebody is appointed to fill a judgeship, give them at least 2 years so people will have an opportunity to tell, are they doing their job? Are they a good judge? That a year is an awfully short period of time for anybody to be able to evaluate a judge. And I was asked the question earlier, how does this affect on the prospect of people running for a judge? Well, of course, nobody but lawyers run for judges. I would think most lawyers would be in favor of it. Normally, if a sitting judge has an opponent, it is because there are lawyers that are dissatisfied with the judge. And the lawyers are in the best position to really know, does the judge work hard? Are they fair? Those kind of things. And it would be fair to somebody appointed to let them at least get their feet on the ground before they have to start running. And it would give the lawyers and the community an opportunity to see how the person performs on the bench.
So you see this as beneficial to the voters then?
I do.
Okay, all right. The League of Women Voters does not take a position on this amendment. So with that analysis, Julian, we will move on to Amendment 4. And Amendment 4 is sponsored by Representative Coleman and co-sponsored by a number of representatives, including our own Mac McCutcheon, who also is the Speaker of the House, Representative Hollis, well, let me just read them all. Representatives Hollis, Rafferty, Bracey, Alexander, Drummond, Moore, Rogers, McClammy, Clark, Gray, Jackson, Warren, Hill, and Wadsworth. So this amendment has a lot of support in the House and from other members. And this is what it says. It says, proposing an amendment to the Constitution of Alabama of 1901 to authorize the legislature to recompile the Alabama Constitution and submit it during the 2022 regular session and provide a process for its ratification by the voters of this state. All right. Let's go to the League of Women Voters and what they have provided to us as a summary. Plain language, this would allow the Alabama legislature, when it meets in 2022, to draft a rearranged version of the state constitution. This draft could only do these things. 1, remove racist language. 2, remove language that is repeated or no longer applies. 3, combine language related to economic development. And 4, combine language that relates to the same county. No other changes could be made. Again, this is the plain language summary provided to us by the League of Women Voters. Julian, what's your analysis?
To me, this is the most important amendment on the ballot. And it is an attempt to modernize, to an extent, the Alabama Constitution. What the summary did not say is that it begins with, upon recommendation of the director of the Legislative Services Agency. And that's a man named Othniel Latham, who is one of the most competent men I've ever known and one of the most knowledgeable men of Alabama law and the Alabama Constitution. He heads the Legislative Services Agency. He will be charged, if this passes, to come up with these revisions in these 4 areas. he will present them to the 2022 Alabama legislature. The legislature then must act on them as if it's a constitutional amendment, which it would be. 3/5 of the votes in the House, 3/5 of the vote in the Senate. And then it would be on the ballot. It would be a constitutional amendment and come back so the Alabama voters would have a chance to say yes or no. The question, and the legislation does not answer this, the legislation proposing this amendment. Okay, the director of the Legislative Services Agency comes up with a draft and presents it to the legislature. Can the legislature play with that draft, delete from it, add to it, or do they must vote it up and down? That is not answered in this. But the real check that voters have is whatever the legislature does will come to the voters, and the voters must vote it up or down. It's a very limited, but I think a needed and very good start. The removal of the racist language has been an issue for a number of years. The primary language has to do with freedom of choice. It reads, to avoid confusion and disorder and to promote effective and economical planning for education, the legislature may authorize the parents or guardians of minors who desire that such minors shall attend schools provided for their own race to make election to that end, such election to be effective for such period and to such extent as the legislature may provide. This is the 1950s, 60s freedom of choice situation. The courts have knocked it down. It's no longer in effect. A specific amendment to do away with the racist language was on the ballot in 2004 and in 2012. It was voted down. There was confusion about it and whether or not it would remove the obligation of the state to provide an education to the children of the state, which I think was a subterfuge just to defeat it, quite honestly. But this is as shown by the number of sponsors and who the sponsors are. I think this is a valid attempt to, again, put at least a foot through the door to constitutional reform and try to make Alabama's Constitution a more workable document and to remove the insult of racist language still being in the Alabama Constitution.
Right. Well, you know, as you know, Julian, and some who are watching may know, I was on the editorial board of the Huntsville Times for years, and during my tenure on the editorial board, we actually made a concerted effort to push for constitutional reform. In fact, there was a fairly strong, at one point in time, a fairly strong grassroots movement to do so. So there's a part of me that is pleased to see that there's an effort being made. I will confess to you that I'm concerned about what you raised about the ability of legislators to take whatever draft is presented to them and perhaps to manipulate it in some way without there being, I'll say, explicit accountability for that. So that concerns me. And then I'm also concerned about whether or not this effort will substitute for complete, in the minds of the public and voters, complete constitutional reform, when I would assume that based on just the length of the Constitution itself alone, there's still going to be a lot more work that has to be done. How would you respond to those concerns?
David, I would say this: the fear of what the legislature might do to whatever kind of draft they get. You have to look. it can only relate to removing racist language, removing language that is repeated or no longer applies, combine language related to economic development, and combine language that relates to the same county. And it goes on to say, and that no other changes can be made. So the limitations on the legislature are pretty sharp, that there's not a lot of damage that might be done when a draft came to playing with it. I share your desire. I served on the board of the Alabama Citizens for Constitutional Reform Foundation. I'm going to be a pessimist, David, and this is a very personal opinion. I don't believe Alabama will ever have a new constitution till you get a popular governor in the governor's second term that's willing to bet the farm on getting a new constitution. I just don't think that's going to happen. I think all of us that are in favor of it must be vigilant and continue to work. The first thing I advise anybody that's interested in constitutional reform, the next election, say to the senator, the candidates for senator in your district, the candidates for the House of Representatives in your district, how do you stand on constitutional reform? It was disappointing to me in the Alabama race for governor 2 years ago and in the races for the legislature. I never heard constitutional reform, a new constitution for Alabama mentioned. And it's incumbent upon, I think, everybody that wants constitutional reform to continue to ask our elected officials, what are you going to do about it? One of the real setbacks, there are only two ways of amending the Constitution. One is to call a constitutional convention, and the other is like what we're dealing with here, amendment by amendment. I guess it was in maybe the first Bob James administration. The Alabama legislature passed a new constitution. People forget that. Before it ever went on the ballot, a lawsuit was filed and the Alabama Supreme Court ruled that the entire legislature could not, or the legislature could not adopt an entire new constitution and submit it to the people, that it has to be either a constitutional convention or one amendment by the other. A first step, I think, would be to overturn that by a constitutional amendment to allow the legislature at least to propose a new constitution. I think that's more likely doable than calling a constitutional convention. There are an awfully lot of differences of opinion on that. People think you will get a better constitution if you have a constitutional convention. And I can argue both sides of that all night, which way you're going to get the better constitution. I think this is an important first step. I think the limitations on what this draft can be protect us from monkey shines possibly happening. And I'm not implying that monkey shines happen in the Alabama legislature, but I think I think this is an important first step.
Okay. Well, the League of Women Voters agrees with you, Julian. They are encouraging their members to vote yes to recompile the Alabama Constitution as a step, as you've indicated, toward constitutional reform. The League of Women Voters believes that this amendment is limited in scope to streamlining and reorganizing the Constitution and to removing the racist language that is a terrible holdover from the Jim Crow South. The League assumes that there are safeguards and transparency in place in this recompilation process, and they encourage everyone to remain vigilant as the process unfolds in the 2022 legislative session and beyond. All right, let's move on now to the last two amendments, and I'm mentioning them as a group here because they are unique to specific counties. The first one is Amendment 5, which is unique to Franklin County. And its actual language reads this way. By the way, it's sponsored by Representative Kyle, I believe is how, is that Kyle or Keel? I'm not sure, but Kiel, however that's pronounced. That representative has put forward this bill relating to Franklin County that is proposing an amendment to the Constitution of Alabama of 1901 to provide that a person is not liable for using deadly physical force in self-defense or in the defense of another person on the premises of a church under certain conditions. Amendment 6, which has been put forth by Representative Greer and is being co-sponsored by Representatives Sorrell, Kyle or Keel, and Pettis, relates to Lauderdale County and proposes the exact same language, for Lauderdale County. I'll read it anyway, even though we just read the one for Franklin. Relating to Lauderdale County, proposing an amendment to the Constitution of Alabama of 1901 to provide that a person is not liable for using deadly force in self-defense or in the defense of another person on the premises of a church under certain circumstances. Now, here is the League of Women Voters summary of Amendments 5 and 6. Again, their language is exactly the same, but for two different counties, Franklin County and Lauderdale County. This is the League of Women Voters is calling this Alabama, sort of an Alabama stand your ground law, which allows a person to legally use physical force against another person under certain conditions. Well, actually, this already exists. I'm sorry, I misread that. Alabama already has a stand your ground law, which allows a person to use physical force legally against another person under certain conditions. And this law does not require the person to retreat before using physical force. And so that's the summary that is given here. And again, this is specifically related to what happens on the premises of a church for Lauderdale County and for Franklin County. Julian, what's your analysis?
First of all, for people that county names may not mean anything to, Lauderdale County is in the extreme northwestern corner of Alabama. It's Florence, Sheffield, Tuscumbia, and Muscle Shoals. Below it is Colbert County, and then below that is Franklin County, which is Russellville. I asked the question, what happened to Colbert County if they were putting one up for Franklin and one up for Lauderdale, and I got no answer. As I said earlier, for these to be on the ballot, when they were before the legislature, there was at least one dissenting vote in one or the other houses of the legislature. I am told, and I do not know this, that Attorney General Marshall has said this is not necessary, that Alabama's stand your ground law applies in churches anyway. That's all this does. It is, we have the stand your ground law. And I don't think it's appropriate to get into an argument if that's a good law or a bad law. It's the law statewide. These proposals have been brought up in the legislature and did not pass to make it statewide. Why uniquely they want it in these two counties, I don't know. And as I said, the general rule in Alabama is the criminal law does not differ from county to county to county. It's the same. And I support the league's position. I'm going to vote no on these. My position is this is just the kind of mess that has made the Alabama Constitution the longest in the world. This doesn't need to be in the Constitution. If the stand your ground law does not apply in churches and people want it, pass it statewide. If the Attorney General is correct, it already applies, this is surplus. But why you should have something like that for only 2 counties in Alabama. I asked the question and I did not get an answer. Are there any other counties with a similar constitutional amendment?
Yeah, it seems to me, I like a lot of Alabamians, I'm a member of a church and I go to church, on a fairly regular basis, or, certainly, at least once or twice a month. And I know for a fact that a lot of churches have deacons that are already packing, and and probably quite a few members that are already packing. So, I mean, it seems to me like we've already probably entered into this territory. We just, I'm not like you. I'm not sure what prompts this. It seems a little unnecessary.
David, I think it came out, the incident in Texas where a gunman came into a church. There was an incident outside Nashville, and then the incident in the church in Charleston, South Carolina. Right. I think that's an attempt, a reaction to those probably. I don't know that. I have not talked to the legislators that sponsored them, but I think if the chief legal officer of the state of Alabama has said that this is not necessary, then I just really don't understand why you would have this in only 2 counties.
Yeah. Well, I pity anybody that goes in any of the churches that I frequent, because I think if they're going to have a problem, if they go in there wielding a gun, they're going to find probably 20 or 30 guns pointed back at them. As Julian said, the league takes a position of voting no on this amendment. In fact, the league's position goes in a slightly different direction from Julian's, in that it focuses on this phenomenon of amendments that are unique to one county being subject to a statewide election. And the league's position is that these counties ought to decide what happens in those counties, not the entire state. And then, of course, the league also does go along with the Attorney General's position that this is superfluous because it's already covered in Alabama stand your ground laws.
Well, as I said, uniquely, this has to pass in both the state as a whole and in the affected county. So if it passes in Lauderdale County, but not state at large, it doesn't become a part of the law. Or if it passes state at large, but not at Lauderdale County. So it's a kind of a double whammy. And I just think it does not benefit the state to fill the state constitution with this kind of law.
Right. And let's, if you can give us a brief little, before we run out of time here, if you could give us just a little brief primer, why is is there a constitutional amendment somewhere that requires that it requires these instances where the whole state has to vote on something that only applies to one county in the state? Why does that even exist?
There is a constitutional amendment in regard to local amendments. So this comes right out of the Alabama Constitution. And it used to be, when I first started voting, that they all went on the ballot statewide and were not on the ballot in, you didn't have to carry the county and the state at large. And you could have a local constitutional amendment that carried the state at large and became law that a majority of the voters in the county didn't particularly want to. And David, the variety of local amendments, and I gave a speech a number of years ago on topless dancing and bulldogs, and literally, because you can't have a criminal law in regard to just one county, we have local constitutional amendments on topless dancing, on dangerous dogs. I mean, the list, if you go through them, It's really, when I was doing my research for that speech, I just broke up laughing most of the time on the absurd things that appear in the Alabama Constitution.
Agreed. Agreed. Julian, fantastic analysis. And I think the League of Women Voters also provided us with some great positions, thoughtful positions. I'm going to ask Pam Caruso. Pam, I see you there. If we have the ability to take questions from people, or do we not? I'm not sure quite how that's set up.
We don't. We've had some comments on the YouTube channel, but we've really not had any questions. Well, take that back. The one question is on Amendment 3, and it's posed as, was this really just Jefferson County that amendment was really focused on, and is it that was—
No, it is not focused only on Jefferson County. I understand the impetus for it came out of Jefferson County, but it certainly applies to the state at large.
Okay. And so there's an issue there, as you said, with turnover, right?
Yeah.
Okay. All right. All right. Well, I want to thank Julian and David tonight. This is very helpful. I really appreciate you guys doing this. I just want a reminder for everybody to please vote. Vote. You can vote now. It's every day's election day in Alabama until November 3rd. And you can do absentee at your courthouse, and you can mail it in. Mail-in ballots need to be postmarked by 3 November. And if you do it at your county courthouse, you need to do it the day before on 2 November. And please mail it in as early as possible. And thank you very much. You guys really appreciate it.
Oh, my pleasure. Julian,
Thank you.
Good to be with you, Julian.
Always, David.
All right.
All right. Thank you.
All right. Take care. And thank you to the League of Women Voters.
Yes.